Hi, I'm Mark from Whiteacre Legal, and today's video is about property law, particularly what you can do as a landowner and whether you have a right to a view. Okay, so let's start as always with our disclaimer. This video is not legal advice. Please do not rely on the contents of this video for legal advice. It's meant for general overview or educational purposes only and is not tailored to your specific situation. So please do not rely on this video for legal advice. We accept no liability for reliance on the content of this video. And if you find yourself in this situation or you need specific advice relevant to your particular situation, please contact us at our website and we can direct you where you might be able to go to get that advice if we can't provide it ourselves. I'll also make a copy of these slides that I'm working from today for this presentation. I'll make those available on our website, and you can go to our website to download those for free. All right, now that's out of the way, I'm going to spoil the rest of this video by saying that no, as a landowner, you do not have a legal right to a view. Let me say that again. You do not enjoy any property or specific legal rights entitling you to a view over, for example, a particular aspect or across your neighbour's land, for example. So, as always, due diligence is key, and if you are looking at buying a property, I don't know, in Sydney with views over the most beautiful harbour in the world, in my humble opinion, then you need to be really careful and make sure that a development is not able to go in front of the property that you're buying, so there's no room there for them to build in front of you, effectively blocking your views. Because if someone can build up and block out your views, then you might stand to lose a substantial amount of money, because there might be very little that you could do in that circumstance to retain those views over Sydney Harbour. So be really, really careful about that. All right, now let's talk very generally about property law, and the best way to do that is to look at the case law, and probably the seminal case for this area of property law is Victoria Park Racing. And this is one of the reasons that I thoroughly enjoy property law and love learning about it at university, was that there is usually an interesting story behind the cases, and this case is no exception. I can't imagine myself getting terribly excited about a particular grainy piece of taxation law and two companies, or a company in the ATO arguing over a particular aspect of the Taxation Act, but property law doesn't suffer from that detriment. So in Victoria Park Racing, this is a really interesting case because a fellow lived near a racecourse, and he'd actually built himself Go Australia. He'd actually built himself a seat up on a stand or a ladder or something, so he could look down into Victoria Park Racing grounds. And as might only happen in Oz, he was calling the races from his property where he could see down into the racecourse. Now, not surprisingly, the Victorian Park Racing Club weren't particularly thrilled about this, and they sought an injunction against this fellow to stop calling the races. I think he was calling it on the radio, but to stop calling the races from his property. This case went all the way to the High Court, and the court held that the racecourse owners had no legal right to the view that emanated from their property. So they couldn't stop people looking in and seeing what was going on in there if they were doing it legally, which this fellow was. So it sort of establishes that principle that you can't prevent people from seeing things on your property. Now, one way to think about that, if I own a Picasso painting, for example, and I hang that in my living room, and people walking past my house can see that Picasso, well, I can't very well start selling tickets to people and asking them for money for the view into my house. I could I could build up the fence or something, or put a tree there to stop them seeing it, but you don't have any protection over the view that emanates from your property. Likewise, if you reverse that or you flip it, you don't have rights to the view or the visual sight from your property and into your property. So they're not a property right like people walking across your land or something like that you enjoy. You enjoy a right to stop people from trespassing on your land. Rights to a view are not property rights or legal rights in that way. All right, so the principle from Victoria Park Racing remains pretty unchanged to this day, and it's been supported in a number of cases, most notably or recently the case of Robson and, I'm going to destroy or murder this pronunciation, Leschke. In this case, His Honour Chief Justice Preston stated that the use of land by the defendant, which does not cause something to emanate from the defendant's land, so something is not coming out of the defendant's land like smoke or noise or pollution, something like that, although it nevertheless in some way interferes with the use and enjoyment by the plaintiff of his or her land, will rarely constitute an actionable nuisance. So what His Honour is saying here is, remember, nuisance has a specific meaning in property law or under the common law. What His Honour is saying is that typically where you're not causing something to emanate from your property, that will rarely constitute a nuisance that your neighbours could action or bring a case on. Thus, a defendant may erect a building or other structure such as a fence or plant a tree on his or her land which interferes with the neighbour's enjoyment of their land. The building, structure or tree may spoil the neighbour's view, in the absence of an easement restrict the flow of air onto the neighbour's land, or in the absence of an easement take away light from the neighbour's windows. Yet such interferences are not actionable as a nuisance. Now, they may not be actionable as a nuisance, but there are specific pieces of legislation that you might be able to bring an action under. But what His Honour here is saying is that they're not actionable under the tort of nuisance, which is a specific head in property law. All right, now some of you might be jumping up and down and saying, well, what about Tenacity Consulting? Well, again, a big spoiler here. Tenacity Consulting did not override these fundamental property law principles. It dealt with something else. It didn't create a right to a view for landowners. So some people misunderstand that, but this case did not do that. In Tenacity, the court described in detail the factors that councils should consider when they are assessing the impact on views on a proposed development. So this case was concerned with a development proposal and the impact on people's views of that development proposal. So something slightly different. However, in that case, in Tenacity, the court merely enunciated a planning principle. It didn't establish a proprietary right for landowners to a view. It enunciated a planning principle, what's known as a planning principle. It's important to understand the difference. A planning principle is not binding law. It's something that guides councils when they are making decisions, or planning authorities when they're making decisions dealing with development applications. If council follows planning principles in reaching a planning decision, that decision is more likely to be upheld in a court. But council can still follow planning principles and they can still approve a development even though the detriment to somebody's views might be significant or even devastating. That doesn't preclude the development from proceeding. It's important to understand that. Now, here we have a bit of an overlap between property law and planning law or planning principles. Many local councils or local planning authorities have sought to redress the balance or balance the views of neighbours through planning law or planning principles. So things they'll take into account when they're looking at somebody's proposed development. The controls that councils put into place become one of many factors that courts will consider when they are assessing a development application. So when you lodge a development application, there are many things that or principles that the planning authority needs to take into account. They used to be under Section 79C of the Environmental Planning and Assessment Act. They're now, I think, Section 4.15 of that Act, and it lists the things that the councils or planning authorities need to take into account when they are determining a development application. Some property owners have misinterpreted these planning controls as giving themselves a right to a view. That's not the case, and that's not what arose out of the case of Tenacity Consulting. Again, ultimately, if the development application is compliant with most of the planning controls, the fact that it has a devastating impact on your view may not be enough to prevent that development from proceeding. The council may or does need to take this into account, but it's not necessarily determinative of the council's decision. Okay, so what can you do about it if you've just bought a property and you find out that there's a DA in front of you that will totally block out your views? Well, there's not much you can do about it, but you should always lodge an objection to that and notify the council of your concerns. If you suspect that council have not applied the appropriate planning controls in determining the application, then there are rights to appeal against that decision. But it's really important that you've lodged an objection to that application in the first instance. As always, prevention is better than cure. And if you're looking at purchasing a property with where a significant proportion of that value of the property may be in a view of something, you need to do your homework and you need to determine whether somebody could build you out in the future or block out your views from that property. Now, you also have rights under the Trees Act. I won't go into that act in this video. That's a completely separate video all by itself. The Trees Act deals with people building things on their fence line, or mostly putting in bamboo hedges along the fence line to block your view into their yard, but also blocking your view out across or towards different aspects. And there are specific rights that you as a landowner have under that legislation. That's a completely separate topic to planning principles and property law, which we're talking about today, and I will go into that in another video. Okay, so that's a general overview of property law and your right to a view. As always, I will make these slides available from our website, and you can go to our website to download those slides and to get in contact with us. Please don't forget to like this video and subscribe to our channel. That does wonders for our YouTube metrics, and leave a comment below if there's something that you want me to look into or explain in detail. Okay, so thanks for watching and take care.